Good evening.
Hi,
How are you?
I'm good. How are you?
I'm doing well. It's great to see you.
Good. It's good to see you too.
How's it going? You been busy?
Yeah, busy. Yeah, it's going well.
Good, good.
So I passed my lit, just to let you know.
You did. Congratulations.
Thank you. Yeah, they NCRA was having a sale on all their exams last month.
Yes,
So I was gonna save it for the end, but then I was like, you know what? Who cares? I'm just gonna take it. And so I took it and I passed it.
that's wonderful. Oh my gosh,
So
that's awesome. One to go. That's it.
one left.
That's
So I've been working on it.
you're gonna do it. You're gonna do it. It's just a matter of time. I'm so
And
proud
then
of you.
the Tennessee convention was the Court Reporters Association convention was last weekend. It
Yeah.
started on Friday, so I went to that, and those things are always so like motivating, So I came home afterwards and I was just like ready to go,
So
and
awesome.
yeah. So
Oh my
so that
gosh.
was exciting.
2 down, 1 to go.
I
Yay.
know. I know. I was
Oh my
so
gosh.
excited that I
That's
passed my lit on my first try, because I
that's
know sometimes the lit can like get in your head a little bit, but
yes.
it was it was good.
I'm glad that you took it out of order because, maybe because your expectations weren't, like you weren't putting that pressure on you. And it was like, oh, okay, I
Yeah.
did it.
Yeah.
I'm so
So
happy for you.
thank you. So
Congratulations.
I'm just I don't know. I feel like my confidence is going up a little bit, so that helps, with the 225, and
Yep.
so
Well, I'll make sure and we'll hit 225 tonight. I'll try to get as much in as we can. Okay.
awesome.
Yep. So, all right. Well, we'll go ahead and get started then so you can get through it.
Okay.
All right. Here we go. Let's see. Okay. Ready? Girl wasn't tell much day through never where good start to take let feel oh your call talk will long than us made friend new open need first which people that's went sure seem stop voice very felt took our poll laugh man, okay, clothes, any, came, told, love, watch, arm, anything, aisle, though, put, left, work, guy, hair, next. All right, now let's do some automobile terms. Here we go. Backup lights, mirrors and glass, door alignment, weather stripping, trunk light, dome light, spare tire, heater controls, glove box light, paint and chrome, door hardware, trunk lock, tire pressure, parking brake, tilt steering wheel, neutral safety switch, starter operation, turning lights, floor carpets, engine performance, push button settings, radio settings, heater operation, flares and reflectors, light switch, windshield washers, fenders and bumpers, parking brake handle, brake linings, wheel covers, vent operation, defroster controls, ignition, switch position, seat adjuster lever, horn operation, exhaust valve, directional signals, steering wheel position, heater outlets, intake manifold, cigarette lighter, rattles and squeaks, defroster operation, high beam lights, air conditioning outlets, and low beam lights. All right. Names and addresses. Gwen L. Russ, RUSS, Lake Taylor High School, 1384 Kempsville Road, Norfolk, Virginia 23502. Frederick P. Logan, Logan, 15th Street, Frontier, Colorado 80201. Marie Waldron Ryder, Ryder, Route 4, Halsey Myrtle Grove, Newton, New Jersey 07860. Eileen W. Vattano, Vattano, 207 Pell Circle, Urbana, Illinois 60801. Gail O. Mason, Mason, 905 South 5th Street, St. Peter, Minnesota 55119. J.S. Massey, Massey, 47th and Walnut Street, Philadelphia, Pennsylvania 19139. Cynthia M. Schumerman, Scheuerman, 3438 South Granada Avenue, Spring Valley, California 92077. Barbara J. Flewell, Flewell, 21 Liam Road, Stamford, Connecticut 06903. Annette C. Tarleton, Tarlton, Bowman High School, P.O. Box 513, Wadesboro, North Carolina 28170. All right. Moving on to medical tamers, medical tangle tamers. Here we go. Visceral, gastric, testosterone, vaginal, chiropractic, aneurysm, atrophy, prescribes, melanoma, radiologist, injury, symptomatology, spurt, headache, anterior, fracture, plantar, cardiac, dyspnea, vessel, obstetrician, vertebral, myelogram, atrophic, fever, dorsal, tumor, pathology, spinal, acromegaly, hysterectomy, thoracic, cranium, amniocentesis, hysterectomy, renal, gushing, intravenous, hydrotherapy, myopathy, laparoscopy, and retrograde. All right, let me just date this so I know that we have covered it. All right. Now I've got some initial consonants that start with SW, and they are in the form of sentences. And this is a continuation from our mid-speeds class. And I'm just dating this. Here we go. He is also called a swabber because he is swabbing. The sailor known as a swabby had to swab the deck. The infant was wrapped with swaddling clothes. We divided the swag swiftly. A swage is a swell tool to work with. The swaggering swept in, or let me say that again. The swaggering man swept in. A swain is also a sweetheart. The swale was covered with water. Did you ever see a swallow swim in a swamp? I swam by the swamp buggy. His swamper swore he would swing it. The swami swooped in sweetly. Swanky swells swim when it is sweltering. Your swan song swept them off their feet. A swan dive in the swamp makes me sweat. Don't swing toward the swarm of bees. They swarmed around these sweepstakes. Some Latins are swarthy swingers. Swing and sway with Sammy K. The swastika was Hitler's symbol. All right. Now these are going to be common phrases, you'll phrase as much as possible. Here we go. Ready? With regards, can he remember? Can I remember? Can remember? Can you remember? Could have remembered? Could remember? Did I remember? Did you remember? Do I remember? Do you remember? Does he remember? Had remembered? Have remembered? He remembered? He remembers? I can't remember. I didn't remember. I don't remember. I remember. I remembered. If he remembers. If he remembered. May remember, must have remembered, whether he recollected, which he recollected, which he recollects, which I recollect, which I recollected, which you recollect, which you recollected, who recollected, who recollects, will recollect, would have recollected, would recollect, you recollected, for the record, the records, recross examination, redirect examination, referring to, in reference, in regard, with regard. All right. Now, this is going to be the and it drill. Okay, all of it focuses on the or it. Here we go. The cash, trade it, the stick, the sale, store it, the house, the dish, raise it, the chain, the same, leave it, the truck, the rock, paint it, the chair, the dime, state it, the laugh, the home, plant it, the river, the hair, grade it, the share, the flag, place it, the place, the pair, spell it, the shale, put it, the trial, trace it, the suit, leave it, the smoke, play it, the force, drill it, the last, dress it, the block, plan it, the pride, drive it, the lake, track it, the right, open it, the trail, shake it, the wind, prove it, the plane, pay it, the dog, time it, top it, the cat, tape it, say it, the job, keep it, tip it, the wit, boil it, set it, the ham, kick it, cut it, the cap, name it, pat it, the cup, turn it, hit it, the rat, sell it, wet it, the pal, pass it, grow it, the hut, lug it, the bag, eat it, the case, tap it, the pit, pace it, the cab, tag it, the type, hear it, the hay, row it, the egg, let it, the race, peg it, the rag, meet it, the lot, ask it, the safe, rub it, the keg, call it. All right. Oh, I put one back. I wasn't supposed to do that. All right, so I've got another drill for you. This is going to be the Mr., Mrs., Miss, and Ms. drill. Okay, here we go. The meeting was at Mrs. Proctor's home. Miss Jensen was the speaker and Mr. Ward introduced her. Then the minutes were read by Ms. Lane. Ms. Richards appointed Mrs. Parvis, Miss Little, and Ms. Chapman to the executive committee, but Mr. Gray thought Mrs. Parvis would not work with Miss Little. Miss Little and Ms. Chapman worked together last year, but Mrs. Parvis had never worked with Miss Little. Mr. Gray thinks she will work only with Ms. Chapman. Mr. Jones met with Miss Dodge, Ms. Miller, and Mrs. Green. Miss Dodge and Mrs. Green were late to the meeting. Mr. Jones asked Ms. Miller for a report. Ms. Miller said that Miss Dodge had the material. So Miss Dodge reported that Ms. Miller and Mrs. Green and Miss Dodge had talked to Miss Hart, Ms. Carter, Mrs. Lake, and Miss Rose. Opinions varied. Miss Rose and Mrs. Lake felt we should go ahead, but Miss Hart and Ms. Carter thought we should wait. Mrs. Green added that both Miss Rose and Mrs. Lake had met with Miss Dodge and Ms. Miller on 2 occasions. Mr. Jones asked Miss Dodge what Ms. Miller and Mrs. Green and Miss Dodge knew regarding the work done by Mrs. Lake and Miss Rose. They told Mr. Jones what they knew. All right. One last drill. Actually, I've got two more. Okay, these are going to be just regular Tangle Tamers. Here we go. Resilient padding, excellent condition, recycle aluminum, experienced rescuers, constitutional guarantees, police commander, callers criticized, increasing friction, contagious diseases, festival organizers, sexually cautious, unique understanding, sickening fumes, maintaining continuity, underground fuel tank, sparkling position, announcing employment, and $1 million auction. Okay, our last drill is going to be medical words and their meanings. Here we go. Humerus, the bone that extends from the shoulder to the elbow. Hyperactive, exhibiting more than normal activity. Hypertrophy, abnormal enlargement. Iliac, pertaining to the ilium or flanks. Ilium, the upper part of the innominate or hip bone. Iliac crest, the expanded upper portion of the ilium. Impacted fracture, a fracture in which one fragment is firmly driven into the other. Incised, cut into with a sharp instrument. Infusion, the slow injection of liquid into a vein. Innominate bone, the hip bone. Intracranial, within the skull. Laceration, a wound made by tearing. Lamina, a thin layer or scale. Lumen, the cavity of a tubular organ as the lumen of a blood vessel. Lymph, a weakly alkaline, nearly colorless fluid contained in the lymphatic vessels. Marrow, the fatty substance in the cavity of a long bone. Mastoid, designating a process of the temporal bone behind the ear, well developed and of somewhat formed in adult men, the protruding part of the temporal bone. Media, middle coat of a vein, artery, or lymph vessel. Medial, pertaining to the middle. Mediastinum, the space in the chest between the pleural sacs of the lungs. It contains the heart and all the viscera of the chest except the lungs. Metacarpus, bones of the palm of the hand. Metacarpal, pertaining to the metacarpus. And myelitis, inflammation of the spinal cord or of the bone marrow. All right, moving on to literary and jury charge. I think I put one of them aside on accident. Let me see here. Sorry about that. I purposely set one aside. Give me just a minute here. Darn it. I purposely set this particular one aside. It was a shorter one. Watch, I'll end class and oh, here it is. I found it. Okay. This is an admonition of the witness regarding a deposition. Okay, I'm going to start at 180, but I'm going to work my way to 225 on this one, okay? Here we go. Ready? This proceeding is known as a deposition. The person transcribing the proceeding is a certified shorthand reporter who has also placed you under oath. During the course of this proceeding, I, and perhaps other of the counsel present here today, will be asking you questions pertaining to this lawsuit. Although this proceeding is being held in my office in an informal atmosphere, since you have been placed under oath, your testimony here today has the same force and effect and is subject to the same penalties as if you were testifying in a courtroom before a judge. Specifically, you are subject to the penalty of perjury. Perjury is defined as willfully and contrary to an oath administered, stating as true any material fact which one knows to be false. The penalty for perjury may be imprisonment for not less than 1 year, nor more than 14 years. You are advised that an unqualified statement of that which you do not know to be true is equivalent to a statement of that which you do know to be false. If at any time during the deposition you feel that any question is ambiguous or unintelligible, or that you are unable to understand it, or you fail to hear the questions for any reason whatsoever, please tell the person asking you the question. If you do not so indicate, it will be presumed that you have heard and have understood each question, and that your answer to each question is based upon your complete and full understanding thereof. If after a question has been posed to you, you have any question yourself relating to what has been inquired about, please tell the person who posed the question before you answer his question. The reporter is only able to transcribe audible responses, so please do not nod your head, shake your head, or say uh-huh or huh-uh. Further, the reporter can usually record the words of only one person speaking at a time, so please allow for the question to be completed before you give your response. You will normally be allowed to finish each and every answer before a new question is posed. At the conclusion of this deposition, the reporter will transcribe these proceedings into a booklet form, and you will have an opportunity to read that booklet and make any changes in your testimony that you feel are necessary. However, if you do make changes in your testimony, as it is given here today, I will be entitled to ask you why you made such changes and comment upon those changes before a judge or a jury at the trial of this action. Because of that fact, it is important that all of your answers be full, complete, and correct. Now, if I ask you about any conversations that you have had in the past and you are unable to recall the exact words used in the conversation, you may state that you are unable to recall those exact words, and then you may give me the gist or substance of any such conversation to the best of your recollection. If you recall only part of a conversation or only part of an event, you are requested to give me your best recollection of those events or parts of conversation that you recall. If I ask you whether you have any information upon a particular subject and you have overheard other persons conversing with each other regarding it, or have seen correspondence or documentation regarding it, please tell me that you have or you do have such information and indicate the source, either a conversation or documentation or otherwise, from which you derive such knowledge. In answering, please do not be concerned with whether or not your answer is hearsay, or concern yourself with any technical rules of evidence you think may preclude you in answering. Our purpose here today is not to trap you or to trick you in any manner, but simply to ascertain and discover that information about the facts concerning this lawsuit that you have within your knowledge. At the conclusion of this deposition, the attorneys present may, by agreement, stipulate that you sign the booklet containing your testimony that you will receive from the reporter who is here today, who is taking and transcribing this deposition. If we do so agree, it will be upon the expressed understanding and your promise that you will, upon receipt of the deposition, promptly and as expeditiously as possible, read it, correct it, and if you feel it necessary, sign it under penalty of perjury and return it to the office from which it was sent to you. Do you understand everything that you have just read? Do you have any questions pertaining to either the procedures or what is about to transpire insofar as the deposition is concerned? If so, please ask them now. All right. Hello, Olivia. All right, let's move on to some literary. Okay, and this is on Too Many Meds. Here we go. I'm going to start at 180. And I will work my way to 225. Here we go. If you're like most Americans, you probably start your day with a hot shower, a cup of coffee, and a handful of pills. More than half of us now regularly take a prescription medication, 4 on average, according to a new nationally representative consumer report survey of 1,947 adults. Many in that group also take over-the-counter drugs, as well as vitamins and other dietary supplements. It turns out Americans take more pills today than at any other time in recent history, and far more than people in any other country. Much of that medication use is life-saving or at least life-improving, but a lot is not. The amount of harm stemming from inappropriate prescription medication is staggering. Almost 1.3 million people went to the U.S. emergency rooms due to adverse drug effects in 2014, and about 124,000 people died from those events. That's according to estimates based on data from the Centers for Disease Control and Prevention and the Food and Drug Administration. Other research suggests that up to half of those events were preventable. All of that bad medicine is costly too. The U.S. spends an estimated $200 billion per year on the unnecessary and improper use for medication, for the drugs themselves and related medical costs. According to the market research firm IMS Institute for Healthcare Informatics. Our previous surveys have found that higher drug costs, including more expensive drugs and higher out-of-pocket costs, also strain household budgets, with many people telling us that they had to cut back on groceries or delay paying other bills to pay for their prescriptions. The nation's expensive and harmful pill habit comes in several forms. Taking too many drugs. Nicole Lambert of Williamsburg, Virginia, says she became completely non-functional with pain, rashes, diarrhea, and anxiety from the adverse effects of several drugs, including some of her doctors prescribed to treat side effects from her initial prescriptions. Taking drugs that aren't needed. Jeff Goring of Wisconsin suffered a debilitating stroke shortly after he began taking testosterone, which his doctor prescribed for fatigue, even though the FDA hadn't approved it for that use, according to a lawsuit he's involved in. Taking drugs prematurely. Diane McKenzie from Illinois had regular bouts of diarrhea and vomiting, side effects she attributed to the drug metformin, which her doctor prescribed for pre-diabetes or borderline high blood pressure. But McKenzie found that losing weight controlled her blood sugar levels without the drugs. Why would so many people take so many potentially harmful pills? Partly because while all the drugs pose some risks, they're often essential, treating otherwise deadly or debilitating diseases, notes Andrew Palani, Director of Public Affairs for the Pharmaceutical Research and Manufacturers of America, known as PHRMA, a trade group. To be sure, some people, especially those who are uninsured or underinsured, don't get all of the care they need, including medication. Still, many Americans and their physicians have come to think that every symptom, every hint of disease requires a drug, says Vinay Prasad, MD, an assistant professor of medicine at Oregon Health and Science University. The question is, where did people get this idea? They didn't invent it, he says. They were spoon-fed that notion by the culture that we are steeped in. So it is a culture, says the experts that we consulted, encouraged by intense marketing by drug companies and an increasingly harried healthcare system that makes dashing off a prescription the easiest way to address a patient's concerns. To investigate this growing problem and to help you manage your drugs, we sought expert advice on how to work with the doctors and pharmacists to analyze your drug regimen. We reviewed the drug list submitted by 20 consumer report readers to see whether we could find the problems and alerted them when we did. We also dispatched 10 secret shoppers to 45 drugstores across the U.S. to see how well pharmacists identify potentially problematic drug interactions. And at last, we compiled a list of 12 conditions that are often first treated with drugs, but usually don't actually need to be. A growing tide of risk. Nicole Lambert's problem started with a single prescription when Stressed in her job, her first job as a physician's assistant, a physician colleague prescribed Xanax. I wasn't given any warning about anything at all. It was just presented as a safe drug, she says. Within a few months, Lambert, who is now 38, was depressed, even suicidal. It scared me, she remembers. Over the next 5 years, Lambert said she saw a series of doctors who prescribed more and more drugs. The ADHD medication Adderall to lift her mood and help her focus, another to counter the side effects of the drug, others to improve her appetite and help her sleep, and when her anxiety worsened, another sedative. The combination, she says, made her so ill that she couldn't even leave the house. I saw tons of specialists, she recalls, a gastrointestinal doctor for chronic diarrhea, an orthopedist and rheumatologist for joint pain, a dermatologist for rashes. None of them questioned my list of meds. Lambert's story is hardly unique. The percentage of Americans taking more than 5 prescription drugs has nearly tripled in the past 20 years, according to the CDC. And in our survey, over a third of people 55 and older were taking that many drugs. 9% were taking more than 10. In some cases, multiple drugs are completely appropriate, says Michael Hotchman, MD, of the Keck School of Medicine at the University of Southern California. But as the number of drugs piles up, so does the need for caution. The risk of adverse events increases after someone is on 4 or more medications, he says. That's especially true when multiple doctors are involved. Poor communication between the providers often contributes to drug errors, says Michael Steinman, MD, at the University of California, San Francisco School of Medicine. And seeing more than one doctor is now the norm. 53% of those in our survey taking prescription drugs said they received them from 2 or more providers. Potentially harmful prescribing is all too common, says Stephen Chen, pharmaceutical MD and Associate Dean for Clinical Affairs at the University of Southern California School of Pharmacy, who worked with Consumer Reports to review the medication list submitted by the readers. Chen, like many pharmacists reviewing the drugs, didn't have access to the medical records. Of the 20 lists he reviewed, only 2 received a clean bill of health. Among the other 18, Chen identified 38 potential problems, half of which he considered serious. They included one person taking a combination of blood pressure drugs that could cause potassium levels to spike and trigger dangerous heartbeat abnormalities, and another's mix of a blood thinner, a pain reliever, and baby aspirin that could cause stomach bleeding. Identifying those kinds of risk and untangling potential harmful interactions can be difficult. For Lambert, it meant finding a doctor who was willing to help. Still, stopping the drugs was a long, nightmarish process, she says, because she had become physically dependent upon them, and it triggered painful withdrawal symptoms. Today, while some side effects still linger, she says she feels lucky to be alive. The drugs and the withdrawal for them almost killed me, she said. There's more, but we'll stop there. All right. Interesting. How are we doing on time? Good. We're doing good. Okay, we're going to do one more before we start our Q&A. Okay. I'm going to give you a word list. You're going to hear conjunction, economic, veto power, agricultural, prying, sector, monitoring, surveying, unacceptable, sociological, census bureau, paperwork, semblance, decennial, confidential, discretionary, colleagues, and census. All right. I'm going to read this at 200. Okay. Here we go. Ready? Mr. Speaker, the bill I am introducing today in conjunction with the chairman of the Committee for Monitoring the Census will enable the Congress to better exercise its authority and control over the many census that are gathered by the United States Bureau of the Census. The Bureau of the Census is required by Congress to conduct censuses ranging from the familiar decennial census to censuses that cover a range from agricultural to economic to sociological factors. These census studies touch every American. Congress imposes a penalty for refusing to cooperate with the census in a range to 1 year in jail. The Census Bureau has full jurisdictions over the nature and content of the questions asked. Americans are subjected to a variety of questioning techniques that seek information that is of a private and confidential nature. Our citizens are afforded no means of protection against the prying eyes of the government. Our bill would restore some semblance of balance between the federal government's need to know information and the right of the people of the United States to be protected against the invasion of their privacy. With this bill, the Census Bureau would be required to submit to Congress all questions that are intended to be asked. Both the House and the Senate would have discretionary powers to exercise the veto power over individual sets of questions that are judged unacceptable by Congress. It is of the utmost importance that Congress begin to monitor the work of the Census Bureau. Millions of dollars are being spent surveying the private sector. We must cut down not only on the paperwork, but also on the cost involved. I urge my colleagues to support this bill. All right. Now let's move on to Q&A. This is going to start with plaintiff. And I'm going to start it at 180, and I will work my way to 225. Defense and the court also jump in. Okay, here we go. What is your occupation, Mr. Patterson? I occasionally work as a truck driver, sir. All right. Do you know the defendants in this case, Mr. and Mrs. Knight, seated there at the counsel table? Yes, I do. And when was the first time that you met them? Not knowing the exact date, it was sometime last year, about the latter part of last year. In the fall sometime last year? Yes. Where do you live, Mr. Patterson? I live in Portland, Oregon. All right. Do you know a Mr. Anthony Winston, also known as Tony? Yes, sir, I do. How long have you known him approximately? About 10 years. All right. Did you have occasion to meet the Knights through Mr. Winston? Yes, I did. I met Mr. Knight through Mr. Winston. All right. Do you recall where this meeting was, where you met Mr. Knight? Yes, I met Mr. Knight in Eugene on the corner of 8th and Fremont in a car. What was the occasion for the meeting? Well, after we went to a beer bar, shortly after we met, we went to a bar. We discussed a little place of business that Mr. Knight owned in Eugene. Had you had any conversation with Mr. Winston about this prior to the time you met Mr. Knight? Yes. He told me about this thing, this business in Eugene, and he wanted me to meet Mr. Knight. All right. What was the discussion you had then in this beer bar? This was in regards to a clothing store on the state highway in Eugene, which he had wanted destroyed. And this conversation was with Mr. Knight? Yes, sir. Was anybody else present? Tony was also there at the time. All right. About how long did you talk to Mr. Knight on this date? We perhaps spent approximately a half hour together. All right. What, if any, arrangements did you make about this place of business on the state highway in Eugene? We discussed the money that was to be given to me. All right. And can you relate what that discussion was, please? Well, he said that he was going to pay $100,000 and that the money would sort of be left in escrow with Tony to be paid after the job was completed. All right. Were there any definite arrangements made about when the job was to be done? Well, yes. I went to Eugene once to look at the place about a week after that. The place had to go before the 31st, something to that effect. 31st of what? 31st of what month, I mean? Well, the month of the explosion, was that the 31st of December? I don't know what month it was. What were you talking about? He said it had to be destroyed completely before the 31st of December. Yes, because of some insurance reason it lapsed or expired or something to that effect. Well, now, was it in December that you went to Eugene, or do you recall? I think it was December that I went down there. All right, you stated that you went down there twice, is that right? Yes, sir. Do you remember where you stayed when you were down there? When I was down there the first time, I stayed at the Hyatt Hotel in Eugene. All right. Now, Your Honor, I have what appears to be a registration card from the Hyatt Hotel in the name of Mr. Eric McNabb. I would like this marked as People's Next in order for identification. It will be marked People's 3 for identification. May I see that again, please? Thank you. Now, Mr. Patterson, I will show you People's 3 for identification and ask you if you can recognize the document. Yes, I do. How do you recognize it? That is my signature. All right, and the name on that is Eric McNabb, is that correct? Eric McNabb, yes. This is my mother's maiden name. My mother's name is Deanna McNabb, and my mother's brother's name is Eric. Mr. Patterson, again, looking at the document, the date I believe appears to be November the 13th. Now, is that the correct date that you were there? November the 13th? Yes, Your Honor. Yes, sir. Could you please relate to the jury what you did when you were in Eugene on that particular day? On this particular day? Yes, when you were there at the Hyatt Hotel. Well, I went there to Eugene and I checked in at the Hyatt Hotel from there, and I went directly to a cocktail lounge and waited around until it was about 1 o'clock in the morning. All right, let's switch. We're going to switch this up. All right. Again, I'm going to start this one at 200. I'm going to work my way to 225. Okay. All right, here we go. How are we doing on time? Good. We got lots of time, so that's good. Would you state your full name, please? Geraldine Pearl Houghton. Would you please spell your first name? Geraldine. Do you have a middle name or a middle initial? P. P as in Paul? Well, yes, or Pearl. And how do you spell your last name? Houghton, Houghton. Mrs. Houghton, or is it Mrs. or Ms.? Uh-huh. I've just been handed back a 4-page document which is addressed on the first page to the witness, and on page 4 at line 4 there's a check mark alongside the word yes. Did you place that check mark there? I did. Acknowledging that you understand the statement entitled to the witness? Yes, right. Have you read the statement? Yes, I have. And at line 13 there is a signature of a Geraldine P. Houghton. Is that your signature? Yes, it is. I'd ask that this be marked and appended to the deposition as respondent's first in order. Mrs. Houghton, what I am showing you now is a copy of the subpoena, which is addressed to Jerry Houghton. Do you recognize the subpoena? If it's the same as mine, it looks the same. All right, are you here pursuant to that subpoena? Yes. I will ask that it be marked and appended to the deposition as respondent's next in order. This is the deposition of Geraldine P. Houghton, and we have appearances for the record. Mark Smith on behalf of the law offices of Mark A. Smith, a professional corporation, for the deponent, and James J. Kenny, the law offices of Harvey, Kenny, and Gardner for the deponent. Barbara Westrom for the law offices of Belly, Chulos, and Sayre for Marie A. Hausch. And we are associated with Mark Anderson, who is sitting here to my left. Thank you. Now, do you want to make your appearance for the record, please? Yes, I am Mark H. Anderson, law firm of Boyden, Kennedy, Romney, and Owens. And for the record, I am a member in good standing of the California State Bar. Thank you. All right. Ms. Westrom, what I'm showing you now is a copy of the Association of Attorney, which purports to associate attorney Mark H. Anderson into the case along with your law firm on behalf of the petitioner. Is that correct? Yes. I'd ask that this be marked, excuse me, you intend to file the original? That's correct. I will file that. May we have a copy of the Association of Attorneys marked as respondents next in order, please? Sure. Okay, Mrs. Houghton, what is your address? 13172 Silver Birch. Is that one word? No. Silver and Birch, B-I-R-C-H. What city? Tustin. And your zip code? 92680. Mrs. Houghton, have you prior to today discussed with any person other than your attorney, Mr. Kenny, today's deposition? Yes. And with whom have you discussed the deposition? My husband. And anyone else? No. Have you discussed the deposition with the petitioner, Marie Hausch? Yes. So that we have some names that we can use clearly for the record. You are familiar with Marie A. Hausch. Is that correct? Yes. Do you also know her by the name of Lynn Hausch? Yes. Do you also know her by the name of Marie Erb? Yes. Okay. Do you know her by the name of Lynn Erb? Yes. So if we use any one of those four names, you will know that we are referring to the petitioner. Is that correct? Yes. When did you first meet the petitioner? Many years ago. More than 10 years ago? About 10 or more. All right. And would you characterize your relationship with her as a friendship? Yes. And under what circumstances did you first meet her? Church activities that we were involved in together. Did you attend the same ward? No. Okay. Did you attend the same stake? Yes. And have you had a continuous relationship since then? Yes. All right. Approximately when did you first discuss with Marie Hausch this morning's deposition? Shortly after I received the subpoena. All right. According to the Respondent's Exhibit 2, you were served on August 19 at approximately 1:55 p.m. Did you speak to Mrs. Hausch that same day? Yes. Did you telephone her or did she call you? I called her. All right. Have all of your communications with Mrs. Hausch since the time you were served with this subpoena been by telephone? Yes. There have been no letters or email between you? No. Emails? No. Okay. How about personal visits? No. All right. Approximately what time of day on August 19 did you first speak to Mrs. Hausch concerning this subpoena? I can't remember. Was it within an hour of the time that you were served? Probably longer. All right. Did you speak to her on August 19th more than once? I don't recall. Have you had any conversations with Mrs. Hausch since August 19? Yes. And when was the next conversation following August 19? Lynn and I are good friends. We talk to each other often, a day or a couple of days. And approximately how many times since August 19 have you spoken to Mrs. Hausch? I'm not sure. I would guess 3 or 4. All right. Let's first address your telephone conversation with Mrs. Hausch on August 19. What did you tell Mrs. Hausch? I don't remember. Did you tell her you were served with a subpoena? Yes. Did you tell her anything else? It's okay. Go ahead. Yes. And what did you say to her? I'd like to confer with my client if that's okay. Certainly. You may, if you'd like, step out. It's up to you. I would. Sure. Let the record reflect that Mr. Kenny has now left the room with the deponent, Mrs. Houghton, and coming into the room is Dan Hausch. I would at this time like to object to the presence of Dan Hausch. He is not being deposed, and there is no necessary reason for him being here at this time, and I would ask that he be directed to leave the room. I will join in the objection. Mr. Anderson, do you have anything that you'd like to say? Merely to support them. Okay, well, the attorneys for the deponent and Mrs. Hausch, the petitioner, have asked that Dan leave the room. Dan, you'll have to sit outside for a minute. All right, Dan Hausch has now left the room. Mrs. Houghton, have you had an opportunity to confer with your attorney? Yes, I have. May we have the last question reread, please? Mr. Kenny, I would instruct my client not to answer the question and to claim the privilege provided by Evidence Code 940. Which privilege is that? Against self-incrimination. All right, do you have a foundation? Since we will be making a motion, do you have the foundation for how this testimony could incriminate her so that the record will be clear? We were informed that certain personal property was removed from the residence of your client, the respondent, whose name I do not know, Mr. Hausch. His name is James W. Hausch. Okay, we were informed that certain personal property was removed from the residence of James Hausch. To that extent, I'm instructing my client to claim the privilege. Is she also claiming the privilege under the Fifth Amendment of the United States Constitution? Not at this time. We're claiming the privilege of California Evidence Code 940. Mrs. Houghton, based on the advice of your counsel, are you refusing to answer the previous question? Yes. Do you understand the question that I was asking you? Yes. During the first conversation on August 19 with Mrs. Hausch, the first telephone conversation, what did you say to Mrs. Hausch? Again, the objection stands to the extent that it relates, that her answer may relate to the incidents which I have just related, and I will instruct my client not to answer the question. And are you refusing to answer, Mrs. Houghton? Yes, I am. All right, Mrs. Houghton, during that first telephone conversation on August 19, what did Mrs. Housh say to you? Same objection, counsel. Okay, well, we can have an abundantly clear record, and I understand what you are saying, Mr. Kenny. Let's be sure that the record is clear, though. When you say same objection, are you referring to, go ahead. Well, to the extent that the Evidence Code 940 provides the privilege against self-incrimination, my client claims that privilege. All right, well, for the record, so that we all understand the same privilege, California Evidence Code Section 940 states as follows: privilege against self-incrimination. To the extent that such privilege exists under the Constitution of the United States or the state of California, a person has a privilege to refuse to disclose any matter that may tend to incriminate him, unquote. Mr. Kenny, would you like to state for the record your foundation of how your communication by Mrs. Housh, the petitioner, to your client could possibly incriminate your client? Well, to the extent that the communication could have dealt with the removal of personal property from the residence of James Housh, and we believe that the privilege applies here. All right, well, Mrs. Houghton, I'm only asking now about the events after the time you were served with a copy of Respondent's Exhibit 2, which was the subpoena pursuant to which you have appeared here this morning, and specifically, you were served at 1:55 p.m. on August 19, 2011. After that time, August 19, 1:55 p.m., have you been to the home of James W. Housh, the respondent in this case? I will again instruct my client not to. I'm sorry. Let me confer with my client. Okay, so we are abundantly clear. I'm only asking about after she was served. After August 19? Yes, after August 19. Okay, she can answer no. All right, are you familiar with the respondent, James W. Housh? Yes, I am. Have you known the respondent for approximately the same length of time as the petitioner? Yes, at least prior to August 19. Would you characterize your relationship with the respondent as having been a friendly one? Yes. Have you known the respondent under basically the same circumstances as the petitioner, namely you're commencing with a relationship in the same church? Yes. Have you had contact on many, many occasions during the past 10 years with the respondent? Yes. Do you know where the respondent resides? Do you know where he lives? Do you know where he lives? Do you know which city in which? Don't guess. No. Do you know which city he lives in? I'm not sure. All right. Have you ever been to the respondent's home? Yes. All right. Have you been to the respondent's? Strike that. All right. Now back to where we were. You've not been to the respondent's home since August 19, have you? No. All right, counsel, before we go on, since we are going to be in court on this, let me just tell you that since she has not been to the respondent's home since August 19, and since she has had no in-person contact with the petitioner since August 19, I'd like for you to hopefully eliminate additional difficulty for your client to maybe talk to her for a moment. And I think that she'd find that statement by Mrs. Housh to her are not going to be privileged after August 19. Well, to the extent that your questions would relate to the events which occurred after August 19, we would not decline to answer. To the extent that those questions would relate to incidents which may or may not have occurred prior to August 19, and to the extent that they may have been discussed, she claims the privilege. All right, the position of the respondent is going to be that if this witness, we have no desire to cause your client any trouble. Sure, to the extent that Mrs. Houghton may have obtained knowledge after the fact of some wrongful, criminal, or otherwise activity, she has no incrimination. I disagree. All right, Mrs. Houghton, what was said to you by the petitioner during your first conversation with her on August 19, 2011? Again, I'd like the record to reflect that her answer will only relate to the events which occurred after August 19. All right, Mrs. Houghton, do you understand my instruction? All right, well, only the events that occurred after August 19, right? Yes, we talked about our children. We mentioned landscaping that was growing and planted at Lynn's house. Okay, anything else? We talked about taking a trip together. Where are you going to? Or where were you going to go? We were always talking about taking trips together. No place in particular? No. All right, anything else said to you by the petitioner during your first conversation with her on August 19? Not that I can recall. All right, I asked you a few minutes ago to characterize your relationship with the respondent prior to August 19. Is your relationship with the respondent friendly still today, August 31st, 2011? That's Jim? Yes, as far as I know it is. All right, have you had a telephone conversation with the respondent, James W. Housh, since Well, during the month of August 2011, yes. All right. And who participated in that telephone conversation? Well, was your husband on the line? Yes. All right. And what was the date of that telephone conversation? I don't know. Do you remember the time of day? Evening, early evening, late evening, or I don't recall. All right. Did you place the telephone call to strike that? Has there been more than one such telephone conversation between yourself and the respondent during the month of August 2011? No. Just one? Yes. Did you call him? No. Did the respondent telephone you? Yes. Was the telephone answered at your home, or did you answer your cell, or what call did he make that to? Your cell or at home, or yes. Okay, at home or your cell? It was my cell, but sometimes my husband answers my cell. Okay, in this case, who answered the phone? I'm not sure. Do you think you answered the phone? No, I don't know. All right, did someone else in the family or possibly? Uh-huh. All right, what was said by the respondent to you during that telephone conversation? At first, it was small talk, such as how are you and how have you been? And well, he was, both my husband and I were on the line at first. And when I picked up my phone, my husband had been talking to Jim. So then he took my phone. Tom was talking about his dental practice. Tom, is that your husband? Uh-huh. What is his full name? Thomas Christopher Houghton. All right. He is a dentist? Yes. And where does he practice? That's a good question. Does he practice dentistry? Yes. At more than one location? Yes. Can you give us the locations at which he practices? There's one place in Southgate. I don't know the address. All right. There is another place in Redondo Beach. I don't know the address. And he is also looking to buy another practice. So he's in between, all over the place. And that's the gist of the conversation with Jim. Okay, now did Mr. Housh, the respondent, ask you if you had been to his home? Yes. And what did you tell him? Object to that and instruct my client to claim the privilege of evidence code 940 and not to answer the question. All right, would you like to state a foundation? Same foundation as we have related to all along, to the extent that personal property may or may not have been removed from the residence of James Housh. We claim the privilege provided to by evidence code 940. Okay, Mr. Housh simply asked her, according to the deponent, whether she had or had not been to Mrs. Housh's home or Mr. Housh's home. And you are instructing her not to answer that question? That is correct. All right, well, Mrs. Houghton, are you refusing to answer the question posed to you? Specifically, what did you tell Mr. Housh in response to his question? Yes. All right, and are you refusing on the basis of, on the grounds that your attorney has stated? Yes, I am. And is that true as to each of your, up to this time during the deposition, you've refused to answer several questions? Are the grounds for your refusal the same as your attorney has stated on the record? Yes. Okay, all right, Mrs. Houghton, you've stated that you have spoken to the petitioner, Marie Housh, 3 or 4 times since August 19. Is that correct? Yes. All right, and following August 19, when was the next time you spoke to Mrs. Housh? As I said before, I'm not quite sure. I imagine a couple of days. Have you made any writing whatsoever? Strike that. Mrs. Houghton, a writing under California law includes anything written down on paper. It includes a tape recording or a recording. It includes photographs, emails. It includes photocopies such as a Xerox copy, or anything that is written or otherwise memoranda. Do you understand what encompasses a writing? Yes, I think so. All right. Have you, Mrs. Houghton, at any time made any writing which states events occurring or conversations between you and the petitioner during the month of August 2011? She can answer. Go ahead and answer. Yes. All right. And in what form? Well, I mailed her a copy of the subpoena. Anything else? No. Okay. No email. No. Did you send any type of a letter or note along with the subpoena? No, I don't think so. Was the subpoena mailed to the petitioner at her request? I think it was. Did she ask you to send it to her? Do you even know? Don't guess. I'm not sure. All right, with the exception of mailing a copy of the subpoena, and that's Respondent's Exhibit 2 to the deposition, is that correct? Yes. In other words, you mailed Mrs. Housh a copy of Respondent's Exhibit 2? Yes. All right, and when did you do that? Well, I don't know. Within a day or two of the time you were served? Yes. With the exception of mailing to the petitioner a copy of Respondent's Exhibit 2, have you created any other writing concerning such events? I'm going to object to that. She's answered the same question 3 times, and I think the record is clear on that point. Okay, well, I am going to ask her again because she has told us about a subpoena, and she's not told us whether there has been anything else. Well, you've asked her if she had any written communication, and she said no. You asked her if there was anything besides the subpoena, and she said no. That's at least 2 occasions in this deposition. She has answered your question. Well, all right, I'm going to ask the same question again, and you can object if you want. I'm pretty sure that what the record is going to reflect is, and it's certainly no inconvenience to the deponent. If she's already said no, she can certainly say no one more time. Mrs. Houghton, with the exception of mailing a copy of Respondent's Exhibit 2 to the petitioner, have you created any other writing concerning the events between you and the petitioner or conversations between you and the petitioner during the month of August 2011? Again, I will object, but I will let her answer the question if she likes. No. All right, Mrs. Houghton, following August 19, 2011, when did you next talk to the petitioner? Repeat, please. Following August 19, 2011, when did you next speak to the petitioner? Haven't I already answered that? You have told me about a conversation, but you haven't told me when it was. I called her sometime during the day that I received the subpoena. That was August 19? Okay, I'm asking about after August 19. Okay, it's been a couple of days. It was a couple of days later. All right, and that is the conversation you've already told me about. Is that right? Is that a yes? Yes. All right, now well, let's go forward. If we refer to the conversation a couple of days later as being the conversation number 1, will you understand what we are referring to? Yes, that is fine. That will help us out a little bit. And if we refer to the conversation number 1 as being your telephone conversation with her on August 19, will you understand what we are referring to? That is fine. All right, following conversation number 2, when did you next speak to the petitioner? I don't remember. Do you recall? I really don't recall. Within a week? Probably. All right, don't guess. And if we refer to your next telephone conversation with the petitioner as being conversation number 3, will you understand what we are referring to? During your conversation number 3 with the petitioner, what did you say to her? Well, I don't remember. You do not remember? Did you, during the conversation number 3, discuss with the petitioner anything which, strike that, I will rephrase. During conversation number 3, what did the petitioner say to you? Same thing? Yeah, I don't remember. All right, during conversation number 3, did you discuss with the petitioner anything which had occurred during the month of August and prior to August 19? During the months of, strike that, I will rephrase. During conversation number 3, did you discuss with the petitioner anything which occurred during the months of July and or August 2011? I will instruct my client not to answer that question on the grounds of California Evidence Code 940, and the foundation is the same as I have restated earlier in the deposition, that to the extent that personal property may have been removed from the residence of James Housh, we claim the benefit of the privilege. Well, all right, Mrs. Houghton, are you going to answer the question? No, I am not. Are you refusing to answer on the basis and grounds just stated by your attorney, Mr. Kenny? Yes, I am. All right, during the conversation number 3, strike that. I will rephrase it. Following conversation number 3, was there any other conversation between you and the petitioner prior to this date between conversation number 3 and today? I don't remember. Have you spoken to the petitioner this morning? No, I have not. To your knowledge, has the petitioner been to the residence of the respondents during the months of July or August 2011? I will instruct my client not to answer the question on the grounds of Evidence Code 940. The foundation is the same as I've stated before. To the extent that personal property was removed from the residence of James Housh, we claim that the benefits of the privilege. And Mrs. Houghton, are you refusing to answer the question? Yes, I am. And are your grounds and basis the same as those restated by Mr. Kenny? Yes, they are. Okay, all right. Mrs. Houghton, have you discussed with your husband the fact that you'd be coming to this deposition this morning? Yes, I did. And have you discussed that with him on more than one occasion? Yes, I did. And when did you first have such conversation? When did that take place between you and your husband? When I received the subpoena. Did you telephone him or did you talk to him in person? I don't remember. Have you discussed this morning's deposition with him on any occasion since then? Yes, I have. Have there been many such conversations? Yes. All right, since the first one, did you telephone your husband within an hour of the time that you received the subpoena? Yes, I did. I think he was at work. And what did you say to your husband? I'd like to confer with my client. Sure. I wasn't prepared for that one. I don't know the specific evidence number, but the specific evidence code number. I don't care about the numbers, but we will claim the evidence code privilege stating the confidential communication between the spouses. Spousal privilege? Yes. All right. Well, now, counsel, would you like to state your grounds? Well, to the extent that the communications between Mrs. Houghton and her husband may have related to the removal of personal property from the residence of James Housh, We would also likewise claim the privilege, spousal communication privilege. Well, now you understand that I am at this time only asking what Mrs. Houghton said to her husband. That is true. All right, Mrs. Houghton, are you refusing to answer? Yes, I am. And are your grounds and basis for refusing to answer identical to those what your attorney has just stated? Yes. And we add that California Evidence Code 940 may likewise be applicable to those communications. And to the extent that it is, are you claiming that? That's correct. Mrs. Houghton, following that first, strike that. Mrs. Houghton, during the first telephone conversation with your husband following receipt by you of a respondent's copy of Exhibit 2, namely the subpoena, what did your husband say to you? Can we go off of the record for just a second? Sure. You want to take it? Do you want to state it for the record? Sure. To the extent that my client may or may not have knowledge of the events which occurred in July of 2011 at the residence of James Housh, she will decline to answer any and all questions relating to that subject, and she will decline to answer any questions relating to communications in which that subject may have been discussed. Okay, Mr. Kenny, what I can do is go back to the record and have the reporter reread each question she's refused to answer, and we can cite her for each. Or what we can do is just make one citation for each question she has refused to answer during the deposition. Is that sufficient for your purpose? That's fine. Get an order that she has to answer the questions relating to events which occurred in July of 2011, and we will comply. Okay, fine. Mrs. Houghton, are you refusing to respond to the question regarding to what your husband said to you during your telephone conversation with him on August 19 following your receipt of the subpoena? Yes, I am. And are you refusing on the grounds and basis stated by your attorney? Yes. And you understand those to be Evidence Code 940 and the spousal privilege? Yes. All right, Mrs. Houghton, did you personally visit with the petitioner, Mary Housh, during the month of July 2011? Yes. And was that in the state of California? Yes, it was. Your visit with the petitioner? Yes. Was it within the county of Orange? Yes. So the petitioner came to California, is that correct? Yes. All right. When did the petitioner, to your knowledge, strike that? I will rephrase. During the month of July 2011, when did you first see the petitioner? Well, when did she arrive? That's two different questions. Okay, you're right. When did you first see the petitioner? Approximately July 12. And under what circumstances? I visited her home. Excuse me? I visited her home. Oh, her home in Utah? Uh-huh. All right. And were you on vacation? Was it a social visit or what? Yes, I was not on vacation, but okay. Two questions again. You're right. I'm just trying to speed it up a little bit, trying to get to the questions, and I think you're probably going to refuse to answer anyway. When did you first see the petitioner in the state of California during the month of July 2011? I'm not sure of the date, approximately the 20th, 19th, 20th, 21st, somewhere like that. Did the petitioner stay at your home? Yes. She spent the night? Yes. What day of the week did she first arrive? Again, I'm not sure, Sunday or Monday. Well, July 18 was a Saturday, and July 19 was a Sunday, and July 20 was a Monday. Does that help to refresh your recollection? That's what I meant, like 19, 20, 21. So it was somewhere like a Sunday or a Monday. Did the petitioner attend religious services with you on July 19 here in California? No. Did you, to the best of your recollection, attend religious services on? No. July 19, excuse me. No. To the best of your recollection, were you in California on July 19? Part of the time. So one way or, I'm not sure. It depends. On what? On the 19th or the 20th? Did you arrive back in California on the 19th or 20th? Yes. All right. Did you come back with the petitioner? Yes. All right. What were the circumstances of your visit with the petitioner on July 12th? I was taking a continuing education course at the BYU graduate course in the theater arts. Did Mrs. Housh take the same course? No. Mrs. Housh accompanied you on your trip back to California? Yes. While you were in Utah, did you stay at the petitioner's home? No. What airline did you, strike that? Did you return to California on an airline? Yes, I did. On which airline? I really don't remember. Did you fly into Orange County Airport? I think so. Don't guess. Oh, okay. Did you drive your automobile to the airport when you left California, or did someone take you to the airport, or did you get an Uber, or my husband took me? All right. Did your husband pick you up, or my daughter? Okay. How did you get home from the airport when you returned to California during July? My husband picked me up. It was in Orange County. All right. Did you return on American Airlines? What used to be? I'm not really sure of the airline. All right. We have done a lot of flying in the last year, so I really don't recall. Did anyone accompany you to the state of Utah for your visit in July? Yes. Who? A lady by the name of Jerry Holt. Would you spell her last name? I think that's her nickname. She spells it J-E-R-I. J-E-R-I? I think her name is Geraldine Holt or Jerry Lynn Holt, something like that. How do you spell Jerry Lynn? I don't know. And would you spell her last name, please? H-O-L-T. Was it Miss, Mrs., or Ms.? Mrs. Holt. Did Mrs. Holt return to California with you? No. Did Mrs. Holt go to the petitioner's residence in Utah with you? Once. Did you go to the petitioner's residence in Utah more than once during July? Yes. How many times? Twice, or maybe 3 times? I wanted to change. You can correct it. Go ahead. I did stay with the petitioner at the end of my graduate studies. How many nights? A couple. The course was over on a Friday night, and then I stayed with her until we left for California. I forgot. All right, the petitioner came back with you? Yes. And the petitioner stayed at your residence in California, is that correct? Yes. How many nights? Oh, under a week. More than 3 days? Yes. So is it correct to say 3 to 6 days? Yes. And nights? Yes. All right. Have you previously resided in Fountain Valley? No. Did you know the petitioner when she lived in Fountain Valley? Yes. Do you know a Mary Turner? Yes. Did you and the petitioner visit with Mary Turner during the month of July? Yes. More than once? I'm not sure. I'm referring to a personal visit. I'm thinking I can only remember once. For the record, July 22nd, 2011 is a Wednesday. Did you and the petitioner visit with Mary Turner on July 22nd, 2011? I'm not sure of the day. All right, when you and the petitioner together did visit with Mary Turner, did you go to Mary Turner's residence? Yes. And did you go anywhere except Mary Turner's residence with Mary Turner? Yes. Where? We went to Disneyland. And when did you leave for Disneyland? It was an evening trip. Okay, and then did you visit, when did you stop your trip to Disneyland? Stop? Well, excuse me, I'll rephrase it. When did you leave Disneyland? When it closed. When was that? I believe it stays open until midnight during the summer. What did you do after you left Disneyland? I will instruct my client not to answer that question on the grounds of California Evidence Code 940 and claim the privilege of Evidence Code 940. The foundation is that we believe that the personal property may or may not have been removed from the residence of James Housh, and to that extent, we claim the privilege. Mrs. Houghton, are you refusing to answer the question? Yes, I am. And are you refusing on the basis and grounds stated by your attorney? Yes, I am. Well, we are getting there. To your personal knowledge, did the petitioner contact her son, Dan, after you left Disneyland? Would you explain contact? Yes, well, I was going to have her, if the answer was yes, as far as whether it was by telephone or did she go there, and did she see her or see her on the street or whatever, but contact. In other words, did the petitioner, to your knowledge, have any contact with the petitioner's son, Dan, after you left Disneyland? You know, we are going to be in court anyway, so I am going to instruct my client to claim the privilege of Evidence Code 940 on the same grounds. Okay, Mrs. Houghton, are you refusing to answer the question? Yes, I am. And is your refusal on the same grounds and basis as stated by your attorney? Yes, it is. During the month of July 2011, Mrs. Houghton, did you go to the respondent's residence? Objection, and instruct my client the same privilege of Evidence Code 940, same foundation as stated throughout. It's fine for me if you want from this point forward to say same objection, same grounds and basis. Okay, fine, thank you. Mrs. Houghton, are you refusing to answer? Yes, I am. Are your grounds and basis for refusal of the same as stated by your attorney? Yes, it is. To your knowledge, Mrs. Houghton, has the petitioner been to the respondent's residence in California during the month of July 2011? Same objection, same grounds, same basis. Are you refusing to answer, Mrs. Houghton? Yes. Are your basis and grounds the same as stated by your attorney? Yes. Counsel, would she refuse to answer on the same grounds and basis regarding any questions concerning any alleged visit by either the petitioner or herself to the respondent's residence during the month of July 2011? Yes. Okay, Mrs. Houghton, would you refuse to answer on the same grounds and basis? Yes, I am. All right, Mrs. Houghton, you have a daughter by the name of Kim, do you not? Yes. And how do you spell her first name? Kimberlie. So it's Kimberly. Yes. Does she have a middle name? Uh-huh. And her middle name is what? Dawn. Would you please spell that, please? D-A-W-N. And her age? 17. All right, Mrs. Houghton, have you instructed your daughter to refuse to answer the questions? The same type of questions that you have refused to answer this morning. What I'm trying to do is not call your daughter if I'm going to get the same thing. In other words, I'd like to make it easy on her and totally avoid it so you can understand. If I can answer for the witness, sure, go ahead. I will claim that too. Instruct the witness to make the same objections as I've made at this deposition. To my knowledge, Mrs. Houghton has not instructed her daughter not to answer the questions. All right, Mr. Kenny, you represent Kimberly Houghton, is that correct? Yes, that is correct. And for the purposes of the depositions today, in this case, the House dissolution case, do you so represent Kimberly Houghton? That is correct. And you understand that Kimberly Houghton is scheduled to have her deposition taken at 11 o'clock this morning? Yes, I do. And if she were called as a witness, you would be representing her? That is correct. And if I pose the same or similar questions to Kimberly Houghton concerning the events, including conversations, personal visits, etc., as I have posed to Mrs. Houghton, would you be instructing your client in the same way, namely, to refuse to answer based upon the California Evidence Code 940? That is correct, counsel. All right, and for all attorneys present, we can stipulate that there is no need to call Kimberly Houghton to run through the same thing, or would you prefer that we call her? You can step outside if you'd like. So you understand I am willing to call her, but we can all save a lot of time and probably keep from, so that the record is clear, Kimberly would not be entitled to claim the spousal privilege. So that's the one thing that we would not be able to claim. Let's go off the record, back on the record. Attorneys for Barbara Westrom and Mark Anderson have now returned. What about that? What have you decided? I think that we can all go ahead and stipulate that we are willing to not bring Kimberly in today, and that the evidence code objections will be appropriate for whatever motions you decide to make. Okay, stipulate that I would ask him the same questions and her responses would be the same. Stipulated? Yes. Okay, if it's all right with their counsel, it's all right with us. Yes. To the extent there may be some minor part in which her activity would be somewhat different than her mother's, and to that, I'm sure we are not going to get too technical here. We're only really talking and asking about all we know, what we're asking for. I think this was a trip to the respondent's house, so that's all we are really after here. And also, I've discussed this already with Mr. Kenny while you were out of the room just briefly, and he has agreed to stipulate that in the event that Mrs. Houghton is ordered to respond to one or more questions, that the daughter Kimberly will likewise respond as well. Is that correct? That is correct. You don't have any trouble with that objection, do you? No, I don't. Doesn't affect your client, at least not directly. We're going to, maybe there are some things I can accomplish here. Mrs. Houghton, do you know how to perform acupuncture? No. Acupressure? Yes. Okay, when did you learn that? A couple of years ago. Have you ever practiced acupressure on Mr. Hausch? I'd like to confer with my client, please. Go ahead. I will instruct my client to claim the same objection, same basis, and same grounds. Okay, Mrs. Houghton, are you refusing to answer? Yes, I am. Are the grounds and basis for your refusal the same as your attorney has just stated? Yes, they are. All right, counsel, can we stipulate that rather than to have the deposition reporter read back each and every question which the deponent has refused to answer and have me go through the citation as to each such question, that the citation, which I will now read into the record, will apply to each question the deponent has refused to answer? That will be fine, counsel. That is agreeable. Mrs. Houghton, you are hereby notified that I will, on behalf of the respondent, move and apply for an order of the Superior Court of the State of California for the County of Orange, compelling you, Geraldine P. Houghton, to answer the questions which I have posed to you during this deposition this morning, and which questions you have refused to answer on the various privileges, including California Evidence Code Section 940 and the spousal privilege. Pursuant to the California Code of Civil Procedure, you are including, but not limited to, the sections 2034A, and you are further notified that I will move and apply at a hearing in Department 8 of the Orange County Superior Court on or other such department to which we are assigned by the Court of Orange County Superior Court at 700 Civic Center Drive West, Santa Ana, California, on September 11, 2011 at 1:30 p.m. or as soon thereafter as the case may be called or heard upon by a Superior Court judge, commissioner, or any other appropriate person, or as soon thereafter as the matter may be heard. Reporter, pursuant to California Code of Civil Procedure, including sections 2034A, please direct the deponent to so appear. Counsel, is that sufficient with you? Yes, it is. Any objections? No, that is fine. Mrs. Houghton, do you understand the instructions which with you have just been given by myself and the court reporter? Yes, but I do need them written. We have asked for a transcript to be prepared promptly, and frankly, we expect it to be prepared this week, and your attorney will have access to it. Counsel, you'd prefer that you be given the transcript, wouldn't you? Yes, I would. All right, now because of the sickness, or excuse me, the stickiness of these proceedings. I'm not able to waive the Code of Civil Procedure sections pertaining to Mrs. Houghton's reading and approving, signing, etc., or any part of the provisions, but I am more than willing to provide a copy directly to you, Mr. Kenny. That is fine with me. I think we can all understand that we'd better cross the T's and dot the I's as far as waiving those provisions. So if you'd like to contact me Thursday, I will have a copy for you, and if not Friday, all right? Okay, fine, thank you. And the same courtesy I will extend to both other attorneys. If you'd like to contact me and see when I have a copy, I will be more than happy to make a copy available to you. And Mr. Kenny, do you want to order a copy from the reporter also? No, I do not. Of course, we will like to have the duplicate original from the reporter on behalf of the respondent. Okay, I would like a copy, all right? Send it to the Bel Air office. Any other attorney present want to enter in anything onto the record before we close the record? I'd like a little examination, and we are going to do this, but we need to recess the deposition and rather set of course, you're assuming that you get the order that you are seeking. If you do not, we may in fact not be back in the deposition. What we're going to do, Mr. Anderson, is we're going to recess, but you're right. As far as the courtesy of counsel, probably at the same time, the hearing on September 11, if we do not get the order, then I will probably terminate the deposition at this time. You are no doubt correct, right? Rather than recess the deposition to a date and a certain time, I am willing, if this would be convenient to counsel, that if I get the order, we simply select a date and the time at the time of the hearing on September 11, and in the event that we are unable to mutually agree to a date at that time, then what I'm going to do is simply continue it to September 24, 2011, 9 o'clock a.m., but with the provision that I certainly will cooperate with counsel in trying to establish a mutually convenient date. It's just that when we get so many attorneys involved, it becomes difficult at times. For me, if you could make it later than 9 o'clock, I wouldn't have to come in the night before and stay the night. Sure, what time would you like it? I wish I knew exactly what the morning flights are, but I am not positive. I would say if you made it 11, there ought to be a flight before then, I would hope. All right, how about 11 o'clock then? Fine, that's fine. That's September 24 mark. Yes, which is a Thursday, but we may be changing this at the time of the hearing to accommodate everyone. I don't have my calendar with me today. I don't either. Okay, counsel, that's all the questions I have. In the event that we do not reconvene after the hearing, I would like to ask one or two questions. Sure, go ahead. You testified that you were visiting in Utah to attend some continuing education classes at BYU, and that when those classes terminated, you stayed for, I believe your testimony was, from Friday evening until whenever it was you traveled back to California with her. When you were with the petitioner, did you encourage her to come to California with you? Yes, sure, yes. Are you aware of any health problems that she has? Yes. What are those problems? Well, reserve the objections. I'm willing to reserve the objections if we can stipulate to reserving them. Fine, fine. All right. I'm not sure of the exact problem. Do you know whether do you know who her doctor is? Yes. Who is her doctor? Dr. Duggar. And where is his office? 1870 Main Street, Huntington Beach. Are you aware of whether or not Marie Hausch made? Yes, Marie Hausch made an appointment with him for some time in July. Yes. How did you get that knowledge and information? She made the appointment at my home and I took her. What was the reason that she came to California with you? Was that the reason to the best of your knowledge? Yes, it was. Okay, I have no further questions at this time. Anyone else? Okay, let's take a recess. All right. So I pretty much ran through that. I didn't save a lot of time for read back this time because I wanted to give you guys, that was like pretty much the whole time it was 225. I only spent about 5 minutes in 200 when I first started this. The rest of the time was 225. How did that feel?
Good. Some parts were good, some parts are bad, but pretty good though.
Good. I mean, that was a long stretch as well.
Right. Yeah.
You know, I mean, that's your endurance working right there.
Oh yeah.
So, let's see here.
That was tough for me.
Was that tough?
Just all the going back and forth with the objections and stuff and getting all the designations in. That was a little tough for me.
Yeah. The good news is when you take the RPR, it's just Q&A, you know?
I know.
So keep that.
And you actually have two different voices, usually a male and a female. That kind of helps me too.
Yeah.
But no, this is great practice.
Yeah, it is. Really is. Yeah, it is.
Yeah. I try to really keep it like sustained. I thought I'm just going to keep going with it. Sometimes with when I read 225, if I get in a rhythm, like with the material, it becomes a lot easier to read at 225 because it's like a flowing thing, you know?
Right. No, that was good.
Good. I'm so glad. Yeah, we went through a whole, that was a whole deposition right there.
Wow.
I know, it was perfect timing. Like we finished, I'm like, well, I might as well just keep going because we're going to finish this. It was perfect, you know?
And I guess those code sections are pretty much standard. They use all the time.
Yes.
Yeah.
Yep. They use
at one point I was thinking, I wonder how fast this deposition really went, because we did it in however many minutes. I'm sure they weren't talking that fast.
No. Let's see here. How many pages? Let me tell you how many pages it was. 54 pages.
Wow.
Yeah, so you figure, and we started from the very beginning. Would you state your full name, please? So, you know, you
wow, you're right.
You just went through 54 pages of.
Yeah. Whoa.
And then I started feeling bad for the reporter, thinking, oh man, are they going to make her go back and reread?
Oh, when they said that part about those questions, each question, I said, oh my gosh, no, yes. Read this question, response. Oh no, that was, yeah.
Imagine, reporter, will you go back and reread every question that she refused to answer? Oh, yeah, that would be tough. You know, you have to go back because that kind of started toward the beginning. So
right, it did. Yeah,
you'd have to go all the way back to the beginning.
Yeah.
And you know what? That's like, you're not certifying those questions as you're writing. You're just getting everything. So like, how you're gonna have to sift through all of that on the spot? Like, how would you even? Like, you're not marking the ones. I guess you could just.
You don't anticipate that happen. I mean, that's never happened to me. I mean, of course, I've read back, but it's just been like one or two questions prior. Not, can you just go back and reread every question that she refused to answer? I mean, that's
crazy. That's crazy.
I guess you'd have to go back and just search for, like, I don't know, you search for the term like refuse or
all the objections basically.
Yeah.
And you know what? If that were to happen, I'd just take my time because I wouldn't expect, you know what I mean? It's like you're putting me on the spot here, going all the way back to the beginning of this. I'm not going to rush through. I'm going to
take my time. Yeah.
I mean, that's, you know, that's your license on the line. I wouldn't.
No. Yeah, exactly. Yeah.
But then she didn't have to end up doing it. Thank goodness.
Yeah.
Would it be unprofessional to say that's what the transcript is for? I'm just kidding.
I think somebody else.
You know what? I was going to say something. At the end, everybody's talking about the California STIP and a lot of craziness. But I noticed at the end, he said, I will have a copy available for you. He asked one or two, I'm sure because there was a couple of plaintiffs, more than one plaintiff attorney. There was a lot going on. So you can tell there were more attorneys there. But I noticed he only asked a few if you order a copy. Otherwise, he was going to make the copies for himself and disperse it. And that's what I thought he was saying. I'll have a copy available for you. Is that what he was doing?
Well, and I think, first of all, that makes reporters mad because it's like, that's not right. You know what I mean? That and
it's right in front of her, I'll have a copy available for you, but do you want to order one? I mean, it was just like he's saying, okay, I'm going to have a copy for you and you, but you need to order a copy. So to me, it's like, okay, you're saying in front, you're going to take this transcript apart and make copies.
Yeah. And do you ever see that, Catherine? Because I know you scope for your aunt. Do you ever see that where it doesn't happen very often where they're cheapskates and they say, oh, I'll just make a copy, but do you ever see?
No, I think at least out here in Tennessee, they're pretty, if they are doing it, they're not doing it in front of her face.
Exactly. And that's pretty.
Okay. Yeah.
I know some people have tried some things she's caught on, but and then when she worked in California, that it was very rare. I don't know if it ever happened in front of her face in California, because she worked in LA mostly, and they know the deal, most of them.
I think that only happened to me a couple times, but it's like, really, you're gonna take the time to take that apart and make copies instead of just ordering a copy? It's not very classy. It's pretty low, of course you don't say anything, but it's like, really, and that's why you always ask, like, do you want a copy? Most of the time they say yes, but
yeah.
But it was funny because I don't know if you noticed, but the defense attorney, he did say he was, because he was going to give a copy to someone, but he made it clear he wasn't going to give a copy to the plaintiff. And
he told someone I caught that. Yeah, exactly. Yeah.
And then the plaintiff goes, okay, I'll take a copy.
I'll take a copy. Yeah, exactly. So you're not going to make me a copy. So yeah. Wow.
Cheat.
Yes.
As if they don't get paid enough,
Okay, I know. Yeah.
Oh, well, and I just saw your
about that article you read about the drug, the drugs thing. That was interesting. That's scary, It was wow, I know, because I'm on medication for diabetes and high blood pressure, which is under control. But you sit there and you think, do you need all this? Or what? It just kind of makes you think to be more cautious when you're getting medication. Think I go to one doctor. That's a good thing, but that's frightening. It's really frightening,
isn't it? Though.
Yeah.
I know that happened to my grandpa. He was taking blood pressure or medicine for his high blood pressure, but then what happened was all of a sudden he had kidney failure, and they said, oh, that's the side effect of the high blood pressure. And he died of kidney failure, and my grandma was like, so it helped the high blood pressure, but then it killed his kidneys.
Yeah, exactly. Yeah. It's sad. I know. Yeah.
So there's more to that article, so I'll finish it next week.
Okay.
All right, you guys will have a great night.
You too. Thank you.
Thank you.
All righty.
Thank you, and I'll see you soon.
Okay.
Okay, bye.
Bye.
Bye.